Welcome to my new video channel. Actually, it's probably the same old one. I don't really know that much because I'm technologically that advanced. If truth be known, I'm pretty much technologically retarded. What I'm doing is staring into a video screen and talking and hoping that it comes out the way that I've had people counsel me that it should. So, what I've done is I have combined my dentist comments blog, where I'll put backup documents for the video, and then I will say what I want to say on the video for my audience. Now, the first thing I'm going to comment about is what's happened to the concept of guilt under a postmodern legal system. Years ago, I gave a course on postmodern legal systems, and it was for lawyers. It was continuing legal education. It was 30 some hours of CLE credit, and it was entitled Surviving a Law Practice in a Postmodern Era. I didn't record it and sell it or market it because I don't believe in assembly line education. I figured if somebody wanted to learn about this, he could sit in a class that lasted for, I believe, 8 or 10 weeks. And we had the class discussions and participation and things such as that, because it was a new topic and it's something that lawyers don't generally think about. And it explains what's happening in our legal system, or at least I thought it explained it. Most lawyers don't give a damn about shit like that unless they can get continuing education hours. So I set it up so they could get some continuing education hours, and they could only get them if they attended the class. So, and they had to attend every week, and they had homework, and they had to study and things like this. So I'm 20 years later trying to do a series based on those premises. And I'll use current events, current situations as the criteria for this channel. You might know about 2 weeks ago, there's a truck driver in a runaway truck from Loveland Pass, Colorado, going down an interstate highway, getting to the flat part of the highway in a truck that was out of control. There were truck run-ups on the Loveland Pass that he passed up, probably because he wasn't trained to use them or fearful about using them. He was a young truck driver. He was from a flat area known as Houston, Texas. There are not too many mountains there, particularly mountain passes with steep gradients. So I'm assuming he hadn't much experience. Secondly, he was under 30. Thirdly, the trucking company for whom he drove let the brakes fail. They were faulty brakes. So they put him in this truck, have him driving on the open roads, going up and down mountain passes with faulty brakes. And in the auto crash that happened because of his brakes failure, several people were killed. And because several people were killed, an ambitious district attorney decided to prosecute him on a form of homicide. Reckless endangerment resulting in death, I believe, was the charge, or such new charge such as that. So what we have is a real aggravated traffic violation, escalated into something worse by virtue of the DA's ambition. I think the only logical thing in my estimation uh, that could explain such a decision would be ambition or ignorance. And I think district attorney, we can assume, was at law school and attended law school, paid attention, and passed the bar. So I don't think ignorance can be an excuse there. It has to be ambition. In any event, there was a jackass judge there who hadn't heard of a judgment notwithstanding the verdict, and said that because the legislature, in its infinite wisdom, had made certain offenses mandatory minimum offenses, and they couldn't be cumulative, or they couldn't be, concurrent. They had to be separate, um, substantially separate. He came up with the figure of 110 years and sentenced this Hispanic truck driver to 110 years in prison for causing the deaths of tourists stopped in the traffic jam. Well, even prosecutors thought that was a little bit over the top. But more importantly, the truck drivers decided that it was egregious enough to call for a truck driver boycott of the state of Colorado. So several thousand truck drivers signed statements that they wouldn't drive in Colorado because of the ridiculous sentencing of this person. Well, you wonder how that happened. Well, first off, under common law, you had juries or finders of fact determine whether or not the person was a good guy or a bad guy. And to determine that, the jurors or finder of fact had to determine whether or not he intended to commit a crime and intended to cause harm to a victim or take his property or something like that. Well, prosecutors love to not try cases. They're basically lazy. Their function is to go to cocktail parties and various civic organizations and brag about how great they are. And they can do that by getting convictions. And the best way to get convictions is to set a system up where you don't have to prove anything, particularly intent, because intent's hard to prove. And when I taught, I gave this example of an assault. So in my right hand, I hope, is a pen. And you out there are my class. Now we're talking about an assault at common law. Now, if I am lecturing you people, and I'm using this pen and I'm pointing here and pointing there, pointing to the chalkboard and just gesticulating in Denver, and it's in general, and it falls out of my hand and hits somebody, that is negligence. I didn't intend to hit somebody. It would accidentally flew out of my hand. It's not a crime. It is what they call in law a tort. The consequence is injury to somebody. And because I didn't grab onto the pen with enough strength to keep it from flying out of my hand, then the person whom the pen hit is entitled to compensation. That's a civil assault, a tort. Now, if I'm recklessly doing it, that adds a little bit to the damage, but it's still a civil tort, a civil harm. Now, if I take the pen and I'm a little pissed off at you and I throw the pen at you, wanting to get your attention, my intent was to get your attention, that may be criminal. It was probably in the nature of negligent assault. It would be compensable. I'd have to pay you damages for the harm it had done. But probably I would have a defense of lack of intent because of anger or some other thing. Now, if I'm sitting in class and you're a pain in the ass, And every time I open my mouth and complete a sentence, your hand pops up and you ask a dumbass question. Well, after about 15 or 20 minutes of this, I get mad or angry or whatever you want to say. And I say, shut up and let me finish my thought here. Well, you shut up. And I start on the next thought, and your hand pops up and you want to ask another dumbass question. Well, this happens to me maybe 3 or 4 times. And I say, damn it, shut up. And I throw the pen at you. And it hits you. I intentionally threw the pen. I intentionally wanted it to cause something. That became a deliberate act, an intentional act. And because of that intent, that becomes a crime. That's not assault, a criminal assault. If it flies out of my hand or if I'm tossing it around or something else and it happens to hit you, that is not intentional. That's the difference between a crime and a tort, as they call it in law, or a civil action. Well, intent is very hard to prove. But because the law in this country used to be based on common law, there was a requisite of intent because the common law was based upon Norman law, Anglo-Saxon law, Saxon Spiel, etc., and it required the element of intent. You go back in history to where there were Druids. Druids didn't require intent for injury. So, for instance, under Druidic law, if a child fell out of a tree and broke his arm, you would chop down the tree because it caused injury. It was the guilty party, so to speak. It was the cause of the injury. The old Roman code, based on the Old Testament, of an eye for an eye and a tooth for tooth, etc., that was similar to the Druidic code, and it became the basis for the Roman code and later the Napoleonic law or civil law, which was pretty much the law on continental Europe from the time of Rome on. So one of the big differences is the element of a criminal intent. And it's a big element. And one was based on Christian dogma and Christian thought. The other was pre-Christian, law of Caesar, etc. So when you have English common law, a lot of it was ecclesiastic law. A lot of it was based in what they called equity. But mainly it was a matter of sorting out what kind of person it is. And if you had a screw up, you made him pay for being a screw up. But you didn't put him in jail or clap him in irons or put him in the stocks or whatever. Also, there was a concept of forgiveness in common law. Now, when I taught this subject, both at the Boulder Free School and other places, I would use Victor Hugo's Les Miserables for an example. If you recall that, or hopefully not just the play or musical, but it was about the difference between common law and civil law. And it was about the harshness of Napoleonic Code civil law. If you recall, the guy who broke into a bread store to get bread for his nieces and nephews. He got caught. He went to prison, served time as a thief, and upon his release, he was pretty institutionalized. And the priest took him in, and he robbed the priest getting away and got caught by a policeman. And he was on his way back to the penitentiary for recidivism. He repeated his crime. When the priest whom he robbed said to him, "You forgot these silver candlesticks," and essentially verified that he had given all of these trinkets to the subject or the hero or anti-hero, whatever you want to call him, of the story. So then it's a matter of, could the leopard change his spots? He went on, he got took over a waif child, raised it as his own, became a good guy. gave away money, but the cop who initially put him away, Valjean, thought under common law, once a criminal, always a criminal. And you should dog him until he commits another crime and then slap his ass back in jail. So this was the plot of the deal. And toward the end, the policeman couldn't reconcile what he observed with the training and his background and basic assumptions. So to resolve the contract or the conflict, he jumped off the bridge or a bridge over the Seine River and committed suicide. He was wrong on prejudgment. He was wrong on the fact that you shouldn't forgive criminals, etc. So that's why I used that as a text, because it was non-technical, and I was teaching non-lawyers, mainly sociologists, and it was easier to use that than some textbooks. So when I went to law school, it was based upon common law of England. When we enacted the Constitution, after we became a country here, independent from England, we adopted the common law of England up until a certain point. Then we started to institutionalize or codify the law, and the DA's Association came in and lobbied the hell out of everyone. And the international multinational corporations didn't like the idea of having to hire lawyers everywhere. So they thought it'd be cool if we had a uniform law. And then they wanted to privatize certain things. And it made a lot more sense to abolish common law, where you had to have intangible decision making, and you could do it on a computer matrix. So we got to a position in law right after the Nixon administration where common law sort of became whittled away to the point of abolishment. We had sentencing matrices. Now we have computer-aided artificial intelligence. And the purpose of a judge really is just to convict people and to move cases from the left side of his desk to the right side of his desk with the least amount of resistance possible, and feed subjects or whatever people to put in the meat grinder for the benefit of multinational corporations or the criminal justice police extortion system. So the courts really have become revenue generators for the benefit of private prisons. We have prison industries now, and instead of having, like in the days before the Civil War, where you used to have house slaves and field slaves, now we got the equivalent of house prisoners and field prisoners. But it's the same system, and it's going to end the same way, and a lot of people are getting hurt. So I'm going to start out with talking about specialized legislation like child abuse and things like this, maybe statutory rape, elder abuse, where you get sentenced not because of what you do, but because the victim had certain characteristics. For instance, if you have sex with a 16-year-old, even though she appears to be and represents herself as 18 or 20, and somebody finds out, you're prosecuted and found guilty if you had sex. You didn't, and it was sex on a minor, which means you go away for a longer time, even though you didn't know it or didn't intend to have sex on a minor. Child abuse is the same way now. You have all kinds of definitions of child abuse, which are very vague, and people can be prosecuted for child abuse. And of course, if you're prosecuted for child abuse, then you have to do all kinds of little things like take courses that you pay somebody for, get P tests or whatever they have to pay people for. And it's a good revenue generator for these privatized corporations that are that deal with cheap labor. If you happen to do the same thing with an elderly person, just because somebody's age is at a certain point, then you get a bigger sentence, not for what you intended, or not for what you've done, but the fact that the victim, alleged victim, is over a certain age. So I'm gonna show videos of some of this that I posted in the past under the Dennis Blewett deal, and then I'm going to show you a case going on right now and video from the police. And I demand that you give me feedback on it. I demand that you give me an opinion or whether or not you think it should be criminal, and if so, to that effect. And then I want a separate number of opinions, and I want you to tell me whether you think the prosecutor had a brain or not, or the policeman had a brain or not, or whether the law had a brain or not, or the legislators. And I'm very serious about this because I'm getting to the point I'm going to probably croak one of these times in the near future. Who knows? Um, I've been under rehab for a number of years now, and I finally got back to the position where I can drive a car. And I'm looking forward to that, but who knows? Maybe I'll crack the car up or something. Anyway, I'm not doing this for my health. I'm doing this to try to get a message through to some people, and I want to know if the message is getting through. So please cooperate and tell me what you think. And don't pull any punches. If you think I'm a dumbass, tell me I'm a dumbass or a jackass or whatever. But I hope you think and give some serious thought to some of the things that I say. And with that, I'm going to publish my first dangerous dinosaur opinion, and it's from my YouTube channel. And then the second one is going to be a similar thing with a similar situation dealing with child abuse and the function of that. So please answer my call and have a good evening.